behalf of Mr. Ryan Busick, P number 84554. Mr. Busick, could you please state your name for the record?
Ryan Michael Busick.
This is a date and time set for PCC.
And Your Honor, at this time, I've made a request for the video and digital discovery in this that has not been tendered to me yet, so we'd be requesting an adjournment of the PCC.
All right, there would need to be a green sheet that would need, you may not be aware of that. We'll get you a green sheet to fill that out.
Sure thing, Your Honor.
All right.
Your Honor, just for the record, there was also, the media discovery we have is in the discovery packet and should be sent over to counsel. And then I also, I called yesterday, have not received that yet, but it should be in my system.
All right.
All right. First legal twist. Defense counsel wants more time for digital discovery. For the uninitiated, that's basically video phone records and anything that could help or hurt the defendant's case. But guess what? They don't have it yet. Imagine prepping for battle with no armor.
Your Honor, we would like to address Brian when the court is ready.
Okay. You want the 26th or the 3rd, counsel?
Give me just a moment to check my calendar, Judge. The 26th would be fine if I could be accommodated, say at like 10 a.m. or later.
Well,
I haven't.
You'll likely be in more toward the afternoon, but I will set it at 9, and then we'll place you into a block. We noted what you've indicated, but
Very good. Yeah, I do have a
if
hearing.
he's in custody, you'll be in the 9 o'clock block, I will tell you.
Okay, I may just be tardy for court then that day. I'll be coming directly from court.
All right. Yes, that's about.
Wait, did you catch that? The counsel admits the defendant has no record, but 2 nights in jail were enough to shake him to the core. Now he's asking to be released with a tether. Would you trust someone who just violated bond with an ankle bracelet?
Bond, while I know the court heard me 2 days ago, I would note that, due to Mr. Busick having no record, these last 2 nights in jail have left an incredibly strong impression on him. Not only the seriousness of this case, but the importance of following all conditions of any bond or any court order going forward. He would like to get back out working so he can save his health care for his children and for himself. He would like to pursue a mental health evaluation. I have talked to clinical therapists, one named Virginia Dawson, who works closely with many courts in Oakland and Wayne County, and she's worked with my office for years. She has experience at the 48th and 16th District Court. I've confirmed that she has appointments that would be available to him every single day next week, depending on his schedule. So we would accordingly renew our request for a cash bond that Mr. Busick can afford of $25,000, 10%, Your Honor, with the tether, obviously.
Response from the people.
Your Honor, I believe the court knows where the people stand on bond. At this point, I'm going to object given the fact of the bond violation originally and then the facts of this case. I believe the bond that is currently set at this moment is appropriate for this case, given all that was stated previously on the emergency bond motion, as well as the bond violations that came up this part.
And the court would incorporate its findings a couple of days ago addressing the emergency bond, the emergency bond filed on behalf of the people, and particularly noting that after the point of arraignment, the defendant's conduct, I don't think, would lead the court to believe that this defendant would be able to follow all of the conditions as set without some cash component or significant cash component in place to try to assure his compliance. And also the court does believe, because of those actions, the defendant does pose a risk or threat to the community. And so therefore the court will deny the defendant's motion to reduce the bond in this case once again.
Would you consider a 10% provision on the current bond, Your Honor?
Boom. The motion to reduce bond was denied, and the judge didn't even flinch. Why? Because when someone shows they can't follow court orders once, the court assumes they won't follow them again. Risk to the community equals cash staying locked.
You asked me that yesterday 3 times, and so the answer is the same, no.
Fair enough, Your Honor.
All right.
I hope you and your staff have a good afternoon. Thank you for allowing me to make a record, as always.
Thank you. Court does call the case of the people versus Wesley Brand.
Allie Zenda on behalf of the people.
Good afternoon, Your Honor. Wendy Barnwell, B42505, on behalf of Mr. Wesley Brand.
Your name, sir?
Wesley Brand.
All right. And this is the hearing that has been requested by the defendant regarding the violation.
Yes, Judge. My client at this time wishes to waive that bond violation hearing.
He admits to the violations.
Yes, Judge.
Regarding contact.
I didn't hear you.
Regarding contact with Tanya Wilson.
Regarding the phone calls.
Yes,
if that was the question.
yes.
Yes.
All right. Court will accept the defendant's admission to the violations. I think his bond currently is set at no bond because of the violations or alleged violations in the case pending the hearing. Where do you want to go from here on this case?
We're asking for a preliminary examination, Judge.
You have all the discovery counsel.
Yes, Judge.
People have their witnesses available the 24th.
We'll do our best, Your Honor.
Does the 24th work for you, counsel?
It doesn't unless it's in the afternoon.
It would be all of
Right.
so.
But let me look and see if I could get a better date.
We
You know
have
what?
the-
I'll take the 24th and I'll switch the other date.
So preliminary examination will be set in person, June 24th, 2025, 9 a.m. before Judge Freshour. Bond will continue as no bond is bond. We will.
Okay, here's a hot one. The defendant wants to call his mom from jail. Sounds innocent, right? But the prosecution blocks it hard. Why? Because phone privileges are a legal privilege, not a right. And he already broke that trust once.
Revoke his bond at this time.
Right. Judge, there is one thing though that I wanted to address on.
Yes.
My client wanted to be able to call his mother. His mother has no connection to the complaining witness in this case, nor is he going to use her as a method of communication.
People.
Your Honor, I would just object it. We can't guarantee that she would use her third party to communicate. I don't mind just having
Yeah, I'm not going to allow that to happen at this point in time. I normally wouldn't have a concern about that, but the defendant has already decided that he wishes to engage in activities that would violate the privilege that he has to call people, to talk to people while he's incarcerated. So I'm not going to change that. His phone privileges are revoked in their entirety. All right.
Thank you, Judge.
Thank you, Your Honor.
Court does call the case People versus Holly Brown.
Ashley Lonnie for the people.
Good afternoon, Your Honor. Sam Bernstein here for Holly Brown.
And this was her motion to set aside her plea. I would indicate, and I don't know if counsel's aware, we're proceeding a violation.
That is correct.
Are you aware of the violation?
Yes, Your Honor.
All right. And she's not here.
That's correct, Your Honor.
Doesn't look like it, Judge.
Your Honor, the people at this time would ask the court deny the defendant's motion to withdraw her plea. That doesn't mean she can't refile it later and issue a bench warrant.
I would just ask, instead of just denying it, I mean, it just doesn't need to go forward at this time, and she can renotice it if appropriate later.
Well, here's part of the problem. Part of the problem is this was sent to Judge Freshour for sentencing.
Okay.
She files her motion to withdraw. Since I took the plea, it came back to me. And it's been sitting here while we've been trying to address her motion to withdraw the plea.
If it gets denied, it goes back to Judge
It
Freshour.
goes back.
I'd ask for it to be denied, Your Honor. Thank you. That's smart.
So what I'm going to do is, defendant having failed to appeal.
Defendant knows her own hearing. That's a big no-no. The judge shuts it down, denies the motion, and sets bond at no bond. Translation: she's not walking out of jail anytime soon. Can't ghost court and expect mercy.